In such a situation, negotiation can be powerful tool for reaching an agreement, and instead of opting for litigation or simply accepting one's partner's there. The two parties involved can meet directly to discuss their interests and concerns. During this meeting, it is crucial that both parties are willing to listen and they understand each other's perspective. They might explore various creative solutions to resolve the conflicts, such as sharing intellectual property rights in different geographic markets. Another option could be to establish a royalty system where both parties benefit from the support society and equally manner throughout open dialogue and seeking solutions that satisfy both parties. It is possible to reach a mutually beneficial agreement. The key here is collaboration and the willingness to find a common ground that respects the interests of everyone involved. Remember, negotiation is not just about what's gained, but also about resolving difference in a way that benefits all parties. Thank you for joining us today. Hello everyone, today we'll explore how to resolve a conflict in the business world through our negotiation. Imagine the scenario where the director of an American tech company and the CEO of a Japanese startup at owes over terms of collaboration, the contract to development new software. The main point of conflict the distribution of intellectual property reached for the final product.
Okay, right now I'm gonna be talking about the conciliation. A conciliator is possibly an expert in the technology industry. What he must do is listen to both sides in order to propose a solution. He or she might suggest a division of intellectual property rights based on each company's specific contributions on this specific project. With a competition mechanism to balance any perceived inequalities.
Arbitration. The party agreed to submit their dispute to an arbitrator or panel of arbitrators. After hearing the arguments on both parties and reviewing the evidences, the arbitrator uses point decisions. This decision could be included as specific divisions of intellectual property rights or establishes a mechanism for the assignments of compensation or contribution for each party.
To address the conflict between the US, China, and Taiwan, judicially, the following step could be taken. First, International Court of Justice. Bring the case to the International Court of Justice for a legal resolution on Taiwan's status and the use of force, provide that all parties, China, the US, and the Taiwan, agreed to submit to its jurisdiction. This would allow for a judgment based on international law. 2. On Security Council interventions. Propose a resolutions to mediate the conflict and establishing a framework for peaceful negotiations. Whenever China becomes power as permanent members could be an obstacle. 3. Diplomacy and mediations. Involvement an international mediator or a neutral country to facilitate negotiations between the parties, promoting mutual compromise and reducing the risks of military conflict. The fourth is non-aggressions and autonomy agreements, bilateral. Bilateral agreements could be negotiations to ensure no military interventions and guarantee Taiwan's autonomy without formally declaring independence, alleging in the interest of all parties. These approaches aim for a peaceful and legal resolutions to the conflicts, but their success will depend on political will and cooperation of all involvement, especially in a context of high tensions and strategic rivalry. Thanks.